Hello everyone and welcome to this webinar on Brexit and data transfers. Where are we now? Which is very much a pertinent question here, just a couple of weeks really, well 3 weeks after the Brexit transition period formally came to an end. So we're delighted that you can join us to discuss this topic. My name's Eleonor. I'm a director in the privacy team in London, and I work on GDPR compliance, including, of course, the all-important data transfers. Prior to joining Field Fisher, I was a UK government lawyer and negotiated the GDPR on behalf of the UK, and also worked in the department for exiting the European Union. So Brexit is a subject that I've been thinking about for a number of years, and look forward to sharing some thoughts with you on this topic. And with me is my colleague, Olivier Proust.
Yes, hello everyone. I'm Olivier Proust. I'm one of the partners at Field Fisher's privacy team. I'm based in one of our European offices in Brussels, to be precise, and I'm absolutely delighted to be joining you and to be speaking to this topic with Eleonor this morning. So welcome everyone.
Thank you, Olivier. So do ask some questions. There's a chat box you'll see on your screen. So if you put the questions in there, we will try to answer as many as we can during the course of the webinar, probably at the end. And if we don't manage to get to your question, don't worry, because we will gather all the questions and come back to you by email if we didn't manage to get to the question that you've asked. So I think that ends the formalities. So I will move on now to looking at the structure of this session. So we are looking obviously particularly at the end of the transition period and what happened. So we're going to be talking about the trade and cooperation agreement between the EU and the UK, and in particular the provisions relating to data. And then we're going to look at what the next steps are for data adequacy for the UK, the future policy on international data transfers from an EU and a UK perspective, and then we're going to be asking the question, will the UK keep its EU adequacy decision? So that's quite a loaded question, but I think one that's certainly worth discussing. In terms of what you're going to get out of this session, hopefully, the learning outcomes, by the end of the session, you should be able to better explain to somebody in your company what the EU-UK Trade and Cooperation Agreement said about data flows, what that means in practice in terms of data protection law, and finally, a bit of crystal ball gazing on what the future holds. So turning then first to the Trade and Cooperation Agreement, and this was good news on Christmas Eve, that after a lot of fraught negotiation, I think finally on Christmas Eve the agreement was reached between the UK and the EU. So what did it say in particular about data protection? I've just set out for you here the main takeaways. It really was good news because there was concern that the UK would end up not receiving an adequacy decision perhaps in time for the end of the transition period, and that standard contractual clauses might have to be put in place. That fear was not realised for transfers from the EU to the UK because the Trade and Cooperation Agreement contains provisions which stop that from happening. They create a sort of bridging mechanism where the UK is not to be treated as a third country for the purposes of international data transfers, so transfers from the EU to the UK, but instead there could be a free flow of data continuing for up to 6 months. And that bridging mechanism is in place for the reason that adequacy for the UK really is anticipated in the agreement. And you see that really from the language. It talks about this being an interim measure and really does anticipate that the UK is going to be receiving an adequacy decision. So that really is good news for data protection practitioners. It means that we don't have to go through that onerous process of the mini adequacy assessment that's required under Schrems 2 and the EDPB's draft recommendations in relation to the UK, but can continue to allow free flow of data from the EU to the UK. And of course, that includes the EEA states as well, so Norway, Liechtenstein, and Iceland. So I think also one of the really important and interesting things about the Trade and Cooperation Agreement is that it really does create a greater level of stability for EU to UK data flows than we see perhaps with other adequacy decisions. I think the UK went into this negotiation saying to the EU, look, the adequacy process, the stability of adequacy is just not sufficient for data flows from the EU to the UK, and we want something more to create greater stability for those data flows. And I'm going to talk in a bit more detail about what those stability mechanisms look like in the Trade and Cooperation Agreement, because I think they're very interesting. But first, I think it's worth just looking at how the agreement is actually administered, because that really is something that I think is a big factor in this extra stability that I've been just mentioning. So what you have under the Trade and Cooperation Agreement is what's called the Partnership Council. So that Partnership Council really is there to police, if I can put it that way, the agreement. It's a political body. It has representatives from both the UK and the EU. There's a question mark at the moment about exactly who those representatives would be. There's been evidence taken about that in the UK Parliament, and there is a lack of clarity on that at the moment. But we know that the Partnership Council will have the UK represented at the highest level by a UK minister, Michael Gove, the Chancellor of the Duchy of Lancaster on the one hand, and on the EU side, we will have representatives from the European Commission and the Vice President of the European Commission, Markus Sefcovic. So they've been mentioned, but we don't know exactly who is going to be perhaps slightly sort of lower down in the hierarchy in terms of representatives. So that'll be interesting. And we know that underneath the Partnership Council, there are a number of specialised committees and working groups. And there have been some real questions over how transparent is this process going to be? Because the Partnership Council is very important. It can issue binding decisions, it can issue recommendations, it can actually also amend the agreement. So really important powers here, but in terms of the transparency and how all of this is going to work, I think that's very much an open question at the moment. But the Partnership Council has really important functions in relation to data protection and data flows too, which I just wanted to highlight to you. So this is a provision relating to the Partnership Council and data transfers. So the Partnership Council can make recommendations to the parties regarding data transfers covered by the agreement or by a supplementing agreement. And one of the strengths perhaps of the Trade and Cooperation Agreement is that it can be added to. So we may see, even in the area of data protection, some expansion perhaps of the scope of the agreement. So potentially further agreement on regulatory cooperation might come in under the agreement and be administered in this way by the Partnership Council. But this is really interesting because I think it reflects the concerns of the UK side that adequacy is just not stable enough. We've seen safe harbour disappear. We've seen the same with Privacy Shield. And I think there was a sense that we needed to do something more. And the UK has talked in the past about something they've called Adequacy Plus. And I think that's what we're seeing here in these provisions, because if there is potential for an adequacy decision to be lost, then here we have a mechanism at the political level to give some stability to that adequacy decision and possibly to head off any difficulties with it, or potentially any suspension or invalidation of an adequacy decision in favour of the UK. So I think that that is a really interesting innovation that we see here in the Trade and Cooperation Agreement, and one which has really important practical aspects too, because I think when Safe Harbour disappeared and the Privacy Shield, companies were left to pick up the pieces. Hopefully here we have a mechanism where if the worst were to happen, we will quickly have a political solution, and possibly even a political solution which heads off any difficulties with that adequacy decision. So I think that's very interesting. Just to touch very briefly, I know that most of you won't be concerned about data processing under the Law Enforcement Directive, but I think this gives a sense of how powerful the Partnership Council is. So this is provisions that relate to the loss of adequacy under the Law Enforcement Directive rather than under the GDPR. But what the text of the Trade and Cooperation Agreement does is it envisages the potential for the UK to lose its law enforcement adequacy decision. So this is a situation where deficiencies in the system have led to the relevant adequacy decisions ceasing to apply. The agreement envisages that there might be a suspension of data flows at that point, but this, I think, final point is really important. So the Partnership Council can explore ways of postponing the entry into effect of the suspension, reducing its scope, or withdrawing it. Now, this really is fascinating because it shows that there may be perhaps some significant tensions between the Court of Justice of the EU on the one hand saying the UK's adequacy decision should be invalidated, but the Partnership Council on the other hand being able to provide solutions to that decision and even potentially withdrawing any suspension of data flows following the loss of an adequacy decision. So this is setting up potentially, I think, some points of tension between those two institutions, between the Partnership Council on the one hand and the Court of Justice on the other. So very, very interesting, I think, a very interesting innovation here, and one that gives, as I say, much greater stability to those adequacy decisions, because obviously we talk about the adequacy decision for the UK. In fact, there are two envisaged, one under the GDPR and the other under the Law Enforcement Data Processing Directive. So that brings us to the end of that first segment that we set out in the structure at the start, looking at the Trade and Cooperation Agreement in a little bit more detail and what it has to say about data flows. But of course, a really important element of that is the adequacy process itself. That's what we're all looking towards now for the next just under 6 months for the UK. So at this point, Olivier, you were going to take us through how this adequacy process works in a little bit more detail.
Yes, thank you, Eleanor. And indeed, I mean, I'm sure most of you are already familiar with many of the aspects of the adequacy process, but just to, as a reminder and to make sure that we're all reminded of the key points. I think to start off, it's important to remind people that the adequacy process, the way it's described in the GDPR, is much more detailed and thorough compared to the provisions that existed previously under the Data Protection Directive. And so as you know, the European institution or body that is tasked with this prerogative of assessing the laws of a third country and pronouncing the adequacy decision comes to the European Commission. So the European Commission is the body that that carries out this assessment and in the end issues the decision, the adequacy decision that grants the third country outside of the EU adequate status. And when we speak about adequate status, it's important to understand that it's interpreted as meaning an essentially equivalent level of protection for personal data compared to the standards of the GDPR. So what the European Commission is going to look at is a number of conditions and criteria to assess whether the laws of the third country are essentially equivalent to those of the GDPR. And so obviously, the European Commission is going to look at the laws that govern data protection in the third country, but not only. And I think it's important here also to remind that the assessment is not limited to data protection laws exclusively, but also covers legislation in the field of public security, defense, national security, and criminal law. And more broadly, the European Commission verifies that the third country, the laws of the third country provide for and recognize fundamental rights and freedoms and the respect for the rule of law. So this is something that is much broader than just data protection. And then another key point, particularly in light of recent legal developments and the Schrems II decision, the European Commission also looks at the potential access to personal data by public authorities in the third country in question, and how that is carried out and how that can impact the rights and freedoms of the data subjects in the EU when a public authority in a third country requests access or disclosure of their personal data. And there are a number of other things that the European Commission looks at, such as, for example, the rules on onward transfers of personal data and other international commitments. But I think it's also important to remind that unlike the regime that was set previously under the Data Protection Directive, here the Commission has a more important role in that the adequacy status, once it has been granted, is not something that is set in stone. On the contrary, if you look at Article 45 of the GDPR, it does say that the Commission has now to monitor developments, legal developments in the third country on an ongoing basis. So there is this, and this is a very important aspect of the adequacy regime. It's that after the European Commission has issued its decision, it continues to monitor any legal developments, and particularly if, as a consequence of changes to the laws of the third country, the European Commission realizes or is concerned that the adequate level of protection is no longer sufficient or is not maintained, then it has the power to repeal, to amend, or to suspend the decision. You know, this Article 45 under GDPR also mentions that the European Commission at that point should enter into consultations with the third country. So once again, referring to this idea of an ongoing discussion with the political representatives in the third country whenever that is needed. So that is. I will stop there on the adequacy regime and hand it back to you, Eleonor.
Yes. There are also, I think, supplementary aspects that the Commission will look at as well in terms of adequacy. So these came out in a communication on the 10th of January 2017. And I think these are really interesting because they give a real flavour, I think, of the sort of policy backgrounds to adequacy decisions. So looking at the commercial relationships with the third country as well, is there a free trade agreement being negotiated? But also the extent to which there are geographical cultural ties, personal data flows from that EU country to the third country, the role that the country plays in the field of data protection, and the overall political relationship with the third country. So I think these are really pertinent as well, actually, because adequacy is an important way, and I think we'll come on to how the UK is going to view adequacy in the future as well, because I think that's very important. But it is a way of forging ties and commercial ties with third countries as well. So it isn't just a legal test in a way. There's a really important international policy aspect to it as well for the European Commission.
Yeah, sorry, Eleanor, maybe also it's worth mentioning that more recently the European Commission issued or made public another communication on the 24th of June last year, so in 2020, on the 2 years of application of the GDPR. You can find this communication on the European Commission's website, but here again, it does mention some interesting things about adequacy decisions. For example, the fact that the Commission says it is now required to review the existing adequacy decisions that have already been adopted, and that the Commission says it has already engaged in dialogue with each of the 11 or 12 countries and territories that have already received the adequacy decision. So, you know, we know, for example, that in some of those countries, there are ongoing legislative changes. I'm thinking here about Switzerland, for example, which is a third country with adequate status, and that has recently adopted amendments to its Federal Data Protection Act, which are due to come into force in the course of 2021. So this is, again, just to illustrate the fact that it's an ongoing process, and that the European Commission is now much more involved in maintaining this continuous dialogue with the countries, the third countries with whom it issues an adequacy decision.
Yes, I think it's interesting that all this sort of negotiation, which obviously I think really didn't happen before under the 1995 directive. You got your adequacy decision, and it was more or less a given, and it was very stable. So this ongoing negotiation, I think there's a question mark. To what extent would the Commission itself take the decision that the changes in the legislation which were being put forward by a particular country weren't acceptable? Or will the fact that there is this ongoing negotiation mean that, in fact, people are very influenced by that, and that the lawmakers in the third country will be influenced by that dialogue? And so, although there's a lot more negotiation, and these adequacy decisions may still be as stable as they were under the 95 directive. I think that's an interesting aspect. Olivier, I think we were going to talk a bit about the actual process for adopting an adequacy decision.
Yeah, well, I'll be very brief on this, but once again, this is just to remind everyone that although, as Eleanor has just explained, the UK is going to obtain the adequacy decision. There are a few sort of formal and administrative steps before the actual decision is published later this year. First of all, the European Commission has to issue a proposal, and then the European Data Protection Board will have a chance to provide an opinion. So I guess just stopping or pausing there a minute. The question there is, what is going to be the view of the European Data Protection Board regarding the UK's adequacy decision, and what impact can that have in the process, in the adoption of this adequacy decision? We know that some of the data protection authorities that are part of and are members of the European Data Protection Board have voiced their concerns, or let's at least have made certain reservations. That being said, in this particular process, the EDPB only has an advisory role. This is only an opinion that it will issue, so it cannot sort of block the process, and in the end, the European Commission is the sole body that has the power to adopt the adequacy decision. So I think it will be interesting to see, in the given context, what are the views and what this opinion of the EDPB states, because I think it will probably give an indication of what to expect in the future, more at a national level. What can be expected from some of the national DPAs. Just as a reminder for everyone, but you probably know this, that the European Commission is also a member of the EDPB. And then further down the process, the adequacy decision also has to be adopted by the EU member states. And finally, there's a formal decision at the level of the commissioners of the EU Commission that sort of puts this into its final adoption. So that's, in a nutshell, that's sort of what is going to happen in the coming days and weeks. I think in terms of timing, Eleonor, if I'm not mistaken, I think even though this is maybe not, this has not been made public, but I think we can sort of sense that on both sides, both on the UK side and the EU side, they want to sort of progress fairly quickly, and there is this 6 months period. So we should expect that the adequacy decision for the UK should be adopted in the coming months, and let's say before the end of June, I suppose.
Yes, and in fact, there are sort of two timeframes envisaged in the Trading Cooperation Agreement. It's really, they've given themselves 4 months, which can be extended by 2 months, which is how you get to the 6 months. But I think there's a sense that they want to put this in place sooner rather than later. Absolutely, the text really indicates that. So we should hopefully hear relatively soon that the UK has been found adequate, if that's the way to describe it, and that this process of adoption, is about to start. So yes, I think it will be imminent.
So I think maybe carrying on, we just wanted here on this slide to sort of set the broader scene, because there's so much going on at the moment on international data transfers, and Brexit is just one of the bricks in the wall, so to speak, but there are so many different aspects. So looking at what to expect in the months to come on the EU side, and then Eleonor will sort of explain what can be expected on the UK side. But on the EU side, sort of parallel to this whole Brexit discussion, as you know, the European Commission is also working on a new set of standard contractor clauses at about the same time as the Brexit trade agreement was adopted. A few days before, the European Commission had made public a draft version of the new standard contractor clauses for transfers of personal data from EU member states to third countries, both in a controller or a processor capacity. And I think everyone is very keen to see the final version of those SCCs. As you probably know, these SCCs were put to public consultation, so we need to wait until the end of this public consultation, and then at some point the European Commission will put them into their final form, and a decision will be adopted. Also, another key legal development that took place last year, the Schrems II decision, and the recommendations that were published by the EDPB as a result of the Schrems II case. Here again, these are undergoing a public consultation. So I think many organizations have already started reviewing and perhaps even implementing some of the recommendations in these guidelines. But once again, we are expecting the final version of these guidelines before they become official. And then, coming back to the adequacy decisions, well, obviously the UK is adequacy decision is a key one, but we know that the European Commission is also assessing the laws of other third countries with a view to adopting an adequacy decision for other third countries. Now, we don't obviously have the full details about which countries those are. We do know that probably the one that seems to be quite imminent, at least that is something that the European Commission has communicated on a couple of times, is South Korea. So South Korea has applied for adequacy decision, and so we should expect that in the near future there should be an adequacy decision issued for South Korea. And then the European Commission has said that it has ongoing discussions with representatives of other third countries in Asia and Latin America without really saying which countries those are. We can expect, for example, and this is nothing official, but we can expect that probably Brazil, for example, will apply or has already applied for adequacy decision, given the fact that Brazil has recently amended and updated its own data protection law and has incorporated many of the GDPR principles or similar principles to those of the GDPR into its national law. There are also other countries that often come into discussions, for example, India or Mexico, but I think the process is probably going to take longer for some of those countries. The review of the existing adequacy decisions, I talked about that already. There's another sort of interesting ongoing discussion and development, which is the sort of the interplay between data protection and trade. And so maybe just to share the view on the EU Commission side, and then I'll give it back to Eleonor to share sort of the view of the UK government. But referring back to the communication of the European Council of the 24th of June of last year, there are a few provisions in that communication around the importance of this interplay between data protection and trade, and so the fact that the European Commission does want to promote data protection standards at an international level, and particularly that it wants to develop specific provisions on data flows and data protection in trade agreements, or it has already done so in some bilateral agreements that were adopted recently, for example, with Australia, New Zealand, and more recently with the UK, of course. So we are seeing this as a sort of an emerging trend, and the European Commission does mention that those synergies between trade and data protection instrument should be further explored, that it's important to ensure a free and safe international data flows and are essential for business operations and competitiveness between the different regions of the world. So Eleonor, I think in the UK, that is something that is also important for the UK government to continue to have those discussions on trade, but at the same time, sort of have parallel discussions on data protection issues.
Yes, absolutely. And I think it's fascinating to see this trend and how it's being looked at from the EU and the UK side. Certainly from the UK side, I'll come on in a moment to talk a bit about the national data strategy in the UK, but there is a real emphasis on marrying up data and trade. I mean, the whole point of Brexit, was to become a global trading nation, and what is one of the most valuable engines for trade. It is now data, and it's data flows. I haven't got the statistics in front of me, but data flows are really increasing in terms of the value of them to the world trade. So this is a real imperative for both sides, I think, to start to look at the possibilities here and to look at the interaction between trade and data. But that's something that the UK is being very strategic about. And we see that in some of the emerging trade deals between the UK and third countries, that there are provisions on data flows in order to ensure that that very valuable trade and those cross-border data flows, and therefore that investment and business can really be boosted, and that barriers to trade are removed. Because obviously, if you don't have adequacy or you don't have a free flow of data, that can be a really significant barrier to trade. And I think particularly after the Schrems II case, where data transfers have become really, really onerous.
Yeah, and I think this does show why the adequacy is so important, but on both sides. And I think for everyone who's listening to us, it's not just in the interest of the UK. I think it's extremely important for the EU as well that the UK has the adequate status. Once again, the European Commission has communicated around the importance for the future relationship with the UK that it has and maintains this adequate status, and that it refers to it as an enabling factor for trade, and particularly in relation to digital trade. And also, as mentioned by Eleonor at the beginning of this presentation, the European Commission also views it as an essential prerequisite for the ongoing and future cooperation on law enforcement and security issues. So, we do see that, beyond just a legal mechanism for data transfers between the EU and the UK, it's also there's a strong sort of political willingness that this adequacy regime exists and is maintained to facilitate future exchanges with both of these regions.
Yeah, absolutely.
So that maybe on the final point on data localization, I think Eleonor, that this is probably something that we will be discussing as time goes by. To what extent can the United Kingdom become sort of a hub for data transfers from EU member states to the UK, and is this something that strictly from a data protection standpoint, is this something that can create a risk? I'm thinking more for data controllers in the EU, and sort of maybe looking forward more into the future, depending on how the data protection laws of the UK evolve. But if the laws in the UK were to diverge from the GDPR standards, could this be an issue that companies would sort of store and keep all of the data in the UK if indeed the laws in the UK start diverging from the EU?
Yeah, it's a really interesting question. When the UK is we see this in these new emerging trade deals between the UK and third countries, very against any form of data localization. That's actually written into the deal. So we see that in the sort of draft agreement between the UK and the US, for example, that there should be no sort of unjustified data localization. So I think this is something that the UK really doesn't want to see. But obviously, in practice, if and I'll come on to talk about this when I talk about future policy on international transfers in the UK. But I think the UK does need to balance really this idea of the free flow of data and that sort of thing with keeping its EU adequacy decision. And if there were to be divergence in terms of the standards, then I think that does pose a difficulty for controllers and processors sending data from the EU to the UK. But then, if there were to be onward transfers, which weren't necessarily going to be, well, the perception might be that there isn't the sufficient safeguard there, and that data localization might be required. So yeah, I think there's an
Yeah,
interesting tension.
exactly. No, I was just going to add to that, Eleanor, that I think on the EU side, it's going to be interesting to see the role of the EU data protection authorities on onward transfers from the UK. because while the initial transfers to the UK are going to fall under the adequacy regime, and that is not going to raise any particular issues. What could raise some issues are going to be those onward transfers from the UK to other third countries, for example, to the United States, but not only. It could be other countries as well that do not have the adequate status, and therefore, as you know, under the GDPR, the guarantee for a sufficient level of protection of personal data has to follow the data, including when it is onward transferred to other third countries. And so that, I think, is going to be the challenge for EU companies that transfer their data to the UK. We are going to see discussions in contracts with companies that are based in the UK, whether these are service providing companies or even data controllers. And as I said, it will be interesting to see how this is enforced by the EU data protection authorities.
Yeah, absolutely. So looking in a bit more detail at what the UK's future policy is going to be, you'll see there are lots of quotes here, and that's because this is taken from the National Data Strategy, which is really interesting, looking at how the UK wants to position itself now the transition period has ended and the UK is fully out, if I can call it that way, of the EU treaties and no longer a member state. And the UK is really ambitious about its role in terms of data. So it talks about being a global leader in data, a champion of free trade. And we do see this matching, as it were, of the trade concerns or the need to trade, the need to create those relationships with third countries, but also the importance of data in doing that, the importance of data to growing trading relationships and economies between the UK and third country partners. And I think it's going to be really interesting to see the extent to which, in order to facilitate that trade, the UK starts to negotiate UK data adequacy with third countries to allow that free flow of data and to allow those trading relationships to become really fruitful and to remove those barriers to trade. So the UK regime is exactly the same as the EU regime. Article 45 of the GDPR has been translated into Article 45 of the UK GDPR. So all of those issues that Olivier outlined, what's the data protection regime like in the third country, adherence to the rule of law, fundamental rights, those criteria will apply to UK adequacy decisions. But obviously the dynamic is somewhat different because I think the UK does want to. I mean, there is a sort of, as I say in the National Data Strategy, a real sense that this is an important thing to strengthen those relationships. And of course, adequacy is by far the best mechanism to allow a free flow of data. So I think we'll see the UK potentially pursuing, as it says in this National Data Strategy, UK data adequacy with global partners. There was a lot of speculation about whether the UK was thinking of dropping its data protection standards during the negotiations on the Trade and Cooperation Agreement. So there was a real question mark, would the UK get adequacy, because was it going to simply ditch what it had said it was going to do on data and go for a much sort of lower standard of protection? I mean, that doesn't seem at all, if you read the National Data Strategy, to be on the cards. The UK has adopted the GDPR as domestic law and is committed to high data protection standards. And we also see that in the Trade and Cooperation Agreement, that both parties have undertaken to maintain high standards of data protection. So I don't think we'll see a drop in standards from the UK, but I think what we will see is an attempt to try to make the regime as agile as possible. So things like certification mechanisms, codes of conduct, all of those things which can help businesses and particular trades, if I can put it that way, to have codes of conduct and to be able to use those in order to facilitate compliance and make it less burdensome. I think we'll see the UK focusing quite a lot on that, because as is set out in the national data strategy, there is a sense that the regime that's in place should not be burdensome, overly burdensome for smaller businesses. So I think we will see a lot of development actually from the UK in this space, because I think the policy on international transfers is really right at the heart of the post-transition period vision for the UK economy and for UK trade. Right. So we felt we couldn't have this discussion without asking that really important question, will the UK keep its adequacy decision? So we talked a little bit about the sort of tensions about wanting to create a regime which isn't too burdensome, which is relatively flexible, whilst keeping high standards and keeping the essentially equivalent standard that allows you to have adequacy. So I think the UK is going to be playing a bit of a game of chess, as it were, because whilst it negotiates with third countries and potentially looks to confer adequacy on those in order to boost trade, the sort of absent negotiating partner in the room will be the EU, because whatever the UK does on the international stage, the EU will be watching and considering, does this mean actually that data that's flowed from the EU to the UK, but then sort of potentially flowed onwards, might not be subject perhaps to the same stringent regimes as we would want to see, and businesses may be left, as Olivier was saying, to deal with that challenge and to put mechanisms in place. So I think this is a really interesting question. It's, as Olivier was saying, it's really crucial to both sides that the UK does keep its adequacy decision, not only from a commercial and trade perspective, but also obviously the law enforcement provisions in the Trade and Cooperation Agreement really are contingent on the UK keeping that adequacy decision. So I would have thought that there would be a lot of pragmatism on this on both sides, and a willingness to negotiate and to ensure that adequacy decision is kept in place. Olivier, I don't know what your thoughts are on this.
Yeah, no, I mean, obviously, I think that is going to be the key question moving forward on this whole issue. I think there are two ways to look at it: the political sort of from a political standpoint, and from a more legal standpoint. I mean, from a political standpoint, I think you're absolutely right that on both sides, the UK and the EU want this adequacy regime to exist and to continue to exist. I don't think, at least not in the short term, in any case, I don't think the UK has any interest in sort of lowering the standards of its data protection regime. I mean, I think also we'll have to see how the discussions at the level of the Partnership Council, how those take place. Because as you mentioned, Eleonor, this Partnership Council is going to be chaired and represented by people in a very high position on both sides. The other thing that I would remind is that at least from the point of view of the EU, the chief negotiator, Michel Barnier, repeatedly said that it was absolutely key for the UK to maintain a level playing field. And this term, the level playing field, was used in not just for data protection, but in all of the other areas that were part of the trade agreement that was adopted. And so if the UK suddenly starts changing its laws, and particularly if it lowers the standards for the protection of personal data, then that could put the whole adequacy regime at risk. But the other point that I just briefly wanted to make as well is more from a legal standpoint. Adequacy decisions can be challenged in court, and so we've seen in the past with safe harbor, with privacy shield that this has those regimes have been challenged. It's gone all the way up to the Court of Justice of the EU. Now, is this going to happen? Is Max Schrems or another association, a privacy association, going to challenge the UK's adequacy decision before the courts? Who knows? It's possible, but that's something that we will have to wait and see whether it effectively happens.
Yes, yes. I mean, I've already been reading some people saying, oh, and the thing that's the big focus actually seems to be the UK's national security legislation, which some commentators think really is just does not bring the UK up to the essentially equivalent test. So that may well be the area in which that which will be sort of foregrounded in any challenge. So yeah, I think interesting times ahead generally for adequacy, because this process of negotiation with the third countries does seem to be something which is going to be happening, and it's going to be happening obviously between the UK and the EU as well.
And Eleonor, I think that there's another interesting point that is maybe worth just briefly mentioning here, is that this adequacy decision is going to apply to the United Kingdom. And in light of what is happening in Scotland, and we know that there may be, I leave it to you to confirm if what I say is correct or not, but there are discussions about a possible new referendum on the independence of Scotland. So sort of forward thinking here, if Scotland one day were to obtain its independence and break free from the United Kingdom, this could possibly, put the whole adequacy regime into peril, wouldn't it, Eleonor?
Oh goodness! I mean that is so complex. When I worked in government, they thought that it would take about 30 years or something to work through all of the issues which would arise from the separation of Scotland from the rest of the United Kingdom. So yes, so I'm sure that adequacy is another thing to add to the difficulties. Yes, I mean, if Scotland is aligned with the EU, the UK has its own standards in several areas, including potentially on data. I mean, certainly the UK regime will start to move away from the EU regime, because Court of Justice judgments will no longer be binding on the UK courts, although they can take them into account. So I think we will see the regimes moving apart inevitably. And so then, yes, if Scotland were to join the EU and to be subject to EU rules, updated EU rules, Court of Justice decisions, but the UK wasn't, then in data and in several areas, I think we would have real regulatory complexity and difficult cross-border issues to contend with. So yes, we're dealing with several layers of uncertainty for the future, I think. Absolutely.
Now, I think just looking at the time, Eleanor, I think we have a few minutes left, and I see that there is a question in the question box, and if anyone still has a burning question, feel free to type it in the question box. So the question is around whether the ICO is likely to adopt or recommend new standard contractor clauses once they are finalized. And I would actually like to broaden that question also to the BCR, because I think, beyond the adequacy decision, obviously, Brexit does raise a number of questions and issues around how the other data transfer mechanisms will apply for when they are relied upon for transferring data from the UK to third countries. And we know that recently, well, just a few days before the end of December, the ICO did make a few statements and publish some communications around a bespoke UK BCR regime. So it does look like the ICO is pushing forward with bespoke BCR and possibly the standard contractual clauses. But Eleanor, I don't know if you want to maybe add a few words to that.
Yes. So the ICO issued some guidance on this, and yes, it does appear as if the UK BCRs is this sort of, I think, adding extra burdens here, which we're seeing quite a lot on Brexit. When the two regimes come apart, and the UK GDPR applies in certain circumstances, and the EU in other circumstances, there is a duplication of burdens here. So yes, so the Information Commissioner basically said that changes are going to have to be made to BCRs, and they slightly depend on whether you've got a BCR that was approved in the EU or in the UK, and there's slightly different timeframes for how quickly you have to do that. But yes, I mean, we're looking at a slightly different regime here, so that just adds to the duplication of work in some ways, in having the EU and the UK BCR. I think it's a really interesting question about the EU standard contractual clauses. Will the UK follow that? The Trading Cooperation Agreement does allow the UK to amend its data protection law to align with EU data protection law during this 6-month period when adequacy is being conferred. So if the new standard contractual clauses came out, would the UK follow that or not? I think that's a really, I think there are several things that the UK government will have to take into account. On the one hand, this sense that the data protection regime shouldn't be overly burdensome for small businesses, and so I think there will be a sense of wanting to ensure that whatever mechanisms the UK has have a high standard of protection, but are not too bureaucratic, if I can put it that way. So might there be a slightly different way of doing standard contractual clauses which would make them less burdensome but keep that same standard of protection? Or is it just so difficult for companies to comply with a UK version and an EU version that just adopting the EU standard contractual clauses actually turns out to be the best option? I can't really see where the UK is going on this at the moment. I think we're getting very little in terms of messaging from the Information Commissioner. So, will it follow the EDPB's recommendations in the future or not? And very little messaging in some ways from the government as well on future policy, and I think that's because the EU adequacy decision is about to come, so they want to focus on that first. So I think all this will become clear in time, and it might all happen quite quickly, but at the moment it's difficult to speculate.
Yeah, I think there's so much that is still unraveling as we speak, and so we'll probably need to come back and as the ICO or some of the other regulators continue to issue communications on all this, then we'll have a clear view on what's going to happen. But I think maybe just as a final point or question also, very practically speaking, what is the impact on your GDPR documentation? So what is the impact of Brexit? And I think what we've seen in the course of 2019 and 2020 is that most organizations were probably, and rightfully so, they were probably waiting for the final outcome of the Brexit and the adoption of a trade agreement before, and particularly whether there is going to be an adequacy decision before making any sort of detailed changes to their GDPR documents. I think now we have more clarity on this. Of course, as we said, the adequacy decision officially has not yet been adopted, but I think it's, we can safely say that the companies now have much more clarity and can start assessing the changes that they need to make, whether it's in their privacy policies or in contracts, and there will be terms and provisions in various documents that will now have to factor in and separate the EU and the UK. So there will unavoidably or inevitably there will be some paperwork and I think all of the privacy lawyers and DPOs on this call know exactly what it is that I am referring to. So I see that we're 1 minute past one. maybe, well, I just wanted to personally thank everyone on the call for their for participating and for the questions. And Eleanor, I hand it back to you maybe for the closing remarks.
Yes. Thank you, Olivier. Well, I think it's been really interesting to discuss these issues. This is such a dynamic area, both in the EU and in the UK, and Brexit only makes it more complex. So, it's useful, I think, to talk about these issues and to monitor where we think things are going, because things are really moving very fast on both sides. So I hope now, finally, at the end, that you do feel better able to explain to someone in your company about the trading cooperation agreement and data flows, what that means in practice, in the context of data protection law, and a little bit on what the future holds as well. So here are our contact details. Please do get in touch if you've got any questions arising from this. If we haven't got to your question, we will write to you with an answer. Thank you so much for attending this webinar, and all the best, and see you in the future, hopefully. Thank you.